is with regards to our own Ghana's former Chief Justice Gertrude Arabasaki Torkornoo, who was well represented by lawyer Falana during her application, which was filed at the ECOWAS Community Court, where she sought to challenge her removal as the CJ. She also made allegations of human rights violations, and also some procedural unfairness with regards to the committee that was constituted to probe the petitions that were brought against her. Lawyer, we heard that the ECOWAS Community Court dismissed the suit that was filed by your client, and in return, you have raised certain objections with the ruling. You see it as one in bad faith. So I would like to hear from you specifically, what legal errors do you believe the ECOWAS Community Court made with regards to their decision on your client, Justice Torkornoo?
Well, with respect to the former Chief Justice of Ghana, the ECOWAS Court was approached to grant her legal relief with respect to the violations of human rights, to fair hearing, right to work, right to information, and right to dignity. The court considered the application, but unfortunately, the court departed from its previous decisions in similar cases. For instance, the court claimed that the court claimed that it could not look at the reasons adduced for sacking her because that would tantamount to interfering in the domestic affairs of Ghana. But we are saying in other cases, in the case of Aladen Tonyobo and Nigeria, in the case of Justice Wo Ho and the Gambia, in the case of Justice Ghana and Liberia, the ECOWAS Court examined the reasons for sacking these judges and came to the conclusion that in the case of Aladen Tonyobo and Nigeria, that the committee that investigated the judge was not properly constituted, in the sense that some of the members did not sit, including the day that a decision to recommend his removal was taken. In the case of Ghana, Justice Torkornoo's matter, the ECOWAS Court said, these are the reasons for removal, we can't go into them. Whereas if you had gone into them, one, that she deployed the judicial staff, which is within the powers of a Chief Justice in any court, in the world. Two, that she traveled with her spouse, her husband. Again, this is allowed by law in Ghana. And these allegations have been dismissed by the Auditor General of Ghana. Another reason was that she recommended certain people to go to the Supreme Court. The appointment were not made by the appointing authority. So you cannot penalize her for that. But in these cases, the court simply said, going to these reasons will be moving into the domestic affairs of Ghana. Again, like I said, in all the other cases, that has not been the case. On the composition of the committee, we did say that the two justices in the committee, our colleagues in the Supreme Court, had sat in the same cases with her. Cases were now used against her. In other words, these judges were sitting as judges in their own courts. In other words, they violated the principle of Nemo Judas in Causa Sua. The court said, well, it doesn't matter. The fact that they have sat on a similar case does not matter. No, that's not what we're saying. We are saying you cannot sanction her while our colleagues who also sat in the Supreme Court bench in Ghana was not also petition. Nobody raised petition against them. But the worst in the case is that the cases that form the basis of the petition were the cases decided by these two eminent judges. And so before forming a prima facie determination of the complaints against her. Again, we cited the Supreme Court judgment in Ghana, and that is the case of Utaderi and Tiger Eye, where the Supreme Court has said when the president or the president and the Council of State are taking decisions under Section 146, it's a quasi-judicial decision. And so you must give reasons why I believe this petition should go into a committee and to what's in the case. Because where our right to fair and was not violated, our lawyers were present throughout the proceeding. No, our allegations, which were not disputed, is that whereas the committee concluded its work on the 25th of August, and I jumped to the 15th of September. But lo and behold, on the 1st of September, the Chief Justice saw the committee members presenting the report to the President, whereas the case had been adjourned to the 15th of September for adoption of written address. So it's a violation of fair hearing. And what then happened? Based on the petition by a lawyer, the court then sat again on the 30th of September, when they had already submitted their report, and gave the impression that two petitions have been dismissed because the petitioners withdrew them. Because they took only one petition. And we are saying, you cannot amend the instrument setting you up. Only the president can say, I have now reduced the petition to examine to one. They cannot so much determine out of three. We are going to deal with only one. The other one, the court also said, we are not bothered, sanitary affair of Ghana, if three members, the civilian members of the panel, the three members of the panel who are not judges, did not take their oath of office before the commencement of their work. This is a legal constitutional matter in Ghana. In the case of Wo Ho, the court made the point. That's the case of Wo Ho and the Gambia. That primary investigations procedure will have to follow due process. Because if it does not follow due process, that will knock the bottom out of the entire investigation. And what is more, the court said a right to information was not violated under Section 128 of the Constitution of Ghana. Any panel, any judicial panel or administrative panel that makes any determination that will affect your interest, you are entitled to a copy of the report because you may want to challenge it in the court of law. In this case, the court said, sorry, there's no evidence that she applied for the report. She didn't have to apply for the report because we tender the videotape of a top official in the presidency who said, we are not going to release the report. The government has decided not to release the report. So how can you now say that the respondent, the government of Ghana, had not violated our right to freedom of information? So there are other areas of the judgment of the court that are total departure from settled principles of law and the jurisprudence of the ECOWAS Court.
Okay, so lawyer, I would want to know, why do you believe that the conclusion made by the ECOWAS Court in dismissing all these allegations filed against the government of Ghana are inconsistent with the court's own jurisprudence?
Well, I have cited the case of Alade Toyibo and Nigeria, the case of Justice Wo Ho and the Gambia, the case of Justice Ghana and the Gambia. I handled the case of Ghana and the Gambia. And in all these cases, the case of Wo Ho, the chief justice of the Gambia was dismissed for corrupt practices, but the court said the procedure was not in line with Article 7 of the African Charter. In the case of Alade Toyibo, the court said the panel did not, the National Judicial Council that investigated her did not follow due process. In the case of Ghana and Liberia, it was also this time the impeachment of the Supreme Court justice was not in accordance with Article 7 of the African Charter. But in the case of the Chief Justice, former Chief Justice of Ghana, the court rather curiously refused to examine the cause, the reasons adduced for assault, our defense before the committee, and the fact that the president did not follow the provisions of the Constitution. And what is more, the presidency said we're not going to release the report of the committee that investigated her. So you have violated our right to even file an appeal against this is like Article 7 of the African Charter. And any court, anywhere in the world, the court also in a very funny manner said her removal as Chief Justice of Ghana already takes care of her removal as Justice of the Supreme Court. Whereas under the Constitution of Ghana, Section 146, if you want to remove the Justice of the Supreme Court, you need three judges of the Superior Court and 2 members of the public. When you want to remove the Chief Justice, you need 2 justices of the Supreme Court and 3 members of the public. So you cannot say our removal as Chief Justice and taking care of our removal as Justice of
Supreme Court.
Until now, no letter has been sent to her. No allegation has been made against her with respect to her performance as a Justice of the Supreme Court. The allegations were made against her as Chief Justice of Ghana. These are mere administrative matters. Because to be a Chief Justice is a political matter, it's an administrative matter. But to be a Justice of the Supreme Court is different from being a Chief Justice of the country.
Yeah. Lawyer, thank you very much. I've seen a petition filed by you calling for an appellate court.
Yes.
I would want to find out, with regards to that particular petition, do you think it could help with Justice Torkornoo's case if there is an established appeal court where she could maybe appeal the judgment or the ruling given by the ECOWAS Court?
Well, as far as the rules of procedure of the ECOWAS Court are concerned, anybody who is dissatisfied with the judgment of the court may apply to the court for a revision of the judgment if there are matters that were not taken into consideration or that was not made available at the time the court was giving its judgment. It's a very restricted area, but many of the member states of the ECOWAS have refused to comply with the judgments of the court on the ground that they are not comfortable with a one-chamber court where you do not have an opportunity to test the judgment of a court. So many of them simply they were not going to comply. We are now saying a decision was taken by the Council of Ministers in 2005 that this ECOWAS court should have an appellate division. I even had gone to court once to the ECOWAS court to say, order the commission to set up an appellate chamber. And what did they say? Oh, Mr. Falana, you have no local standard to challenge the authority of heads of state and ask them to set up an appellate chamber. But with what has happened now, the inconsistencies that have characterized the number of the judgments of the court, and we have cited them, particularly the case of Justice Torkornoo, we are now saying the time has come for the court to have an appellate chamber. And it depends on what the authorities say. They may say, for decisions that were taken from so day to the moment, to the present, we want the appellate chamber that will be set up to review them. Or we may say, within 5 from now, we're setting up an appellate chambers or appellate division of the ECOWAS court. But what is important is that this case, as the case of the former Chief Justice, has strengthened the campaign for the setting up of the appellate chamber, appellate division of the ECOWAS court.
Okay. Lawyer, I would also want to find out, ECOWAS court in its ruling said they believe that your client didn't exhaust the domestic remedies that exist in Ghana. I would want to find out, what do you think the court should have done differently if a belief that the domestic remedies had not been exhausted before she filed a suit?
Under the protocol established in the court and the supplementary protocol, an applicant is not required
to
exhaust domestic remedies. In fact, that makes the court unique.
Okay.
And when Ghana initially raised an objection as to the jurisdiction of the court to determine the matter, the court said, no, we're not bothered with what is going on in your courts. What is before us are allegations that border on violations of human rights. So the court does not require an applicant to exhaust domestic remedies, and that is basic. And that distinguishes the court from any other international tribunal.
Okay. I would also want to find out from you if in the case whereby an appellate court like you are seeking for is actually established, such a division is established, what arguments would you have expected the former CJ to have raised to help with the appeal against the ruling by the ECOWAS Court?
Well, like I've done all day, we will have itemized areas where the judgment of the court cannot be supported, factually and legally.
Okay.
Where the court did not look at certain exhibits, documents tendered before them, where the court did not consider the principles of guiding the Nkommo Wo, whether a judge that sat in the Supreme Court of Ghana in respect of a petitioner can turn around to go to a committee to decide the case he has ruled upon in the Supreme Court, or whether a witness on whose petition you are going to dismiss a chief justice of the country will not give evidence and be cross-examined. In the case of Nigeria, we petitioned the Oputa panel, the Oputa Human Rights Investigation panel, over the burning of the house of the late musician, Fela Nikola Pokuti. President Obasanjo, as a sitting president, came to give evidence before the panel. So, if you are a witness, you have petitioned a judge or anybody for that matter, you cannot hide. You must come to court or the committee and give evidence so that you can be cross-examined.
Okay.
With a view to discrediting your evidence. In this case, the committee adopted a strong procedure by not allowing the petitioner to give evidence.
Okay.
Again, as I said, there were 3 petitions. You cannot take one and on your own decide that you are dismissing
the other 2.
You didn't set up yourself. Only an instrument made by the president could have amended, only the president could have amended the instrument, setting up the committee, and then decide, okay, we now reduce your work. Considering one petition. But the panel cannot on its own. And in any case, she was not aware. They did not serve the motion for withdrawal on her. So the panel conducted that aspect of the proceeding behind her. And it's not allowed either in a regular court or in an international tribunal. These are the key issues that would have been raised in an appellate court if there had been a provision for one.
Okay. So this is a latest update that happened in Ghana here today. So the Supreme Court of Ghana dismissed 4 cases that were challenging the removal of your client, actually.
Yes,
so,
of course.
Yes. So do you think the Supreme Court's decision could maybe have some effect in any way on your client or any future cases where she would want to take the matter to?
No, I haven't read the judgments delivered by the Supreme Court of Ghana.
Okay.
I was only briefed to handle the complaint before the Community Court of Justice. So I can only limit myself to the decision of the ECOWAS.
Okay, all right. So, lawyer, please, I would like to find out what will be the next line of action for your client, Justice Torkornoo?
Again, I'm going to consult with my client. I cannot take a decision for her. We are studying the judgments of the Community Court of Justice, and we shall take appropriate action at the right time. But one that I have taken personally I have led the campaign for the establishment of the court in 2004, which eventually we won that battle, culminated in the setting up of the court in January 2005. Incidentally, it was at the meeting held in Ghana by the heads of state that decision was taken. Since then, I've regularly practiced in the court more than any lawyer in the sub-region. And this, again, as I said, this is a very strange decision. It takes a departure from the jurisprudence of the court. And for that reason, I have already written an application to the authorities to think very seriously, and set up an appellate court for community.
Okay. Lawyer, I would also want to find out again from you. Do you think this could set a bad precedent for future cases that dwells on similar ones like the one Justice Torkornoo encountered with regards to human rights violations in a row, serving the state and all that? Do you think it sets a bad precedent for?
No, I'm very convinced that the court will never, ever rely on this decision. Because like I said, it's a total departure from settled principles of law. I'm talking of principles of law settled by the court. Having regard to the cases I've cited and many others. It's the first time that the court is saying, please go back home. These are internal affairs of your country. No. The court has never said that. Even in this case, when Ghana first raised objection, the court said, no. This is a different court in time. We're not bound by your domestic affairs. So we are dealing with violations, alleged violations of human rights, under Articles 9 and 10 of the supplementary protocol of the court. But when it came to the main judgment, the court suddenly fell back and now said, this is Ghana by domestic jurisdiction of Ghanaian court. We cannot look into that. So the court will never go back to that decision. I'm very convinced about that.
So, lawyer, what do you think is so different with your client's case that the court went against, like you said, legal principles for them to overlook certain things that you think they should have properly looked at?
I am saying, seriously, that once an allegation of violation of human rights by any institution or by any government in the sub-region, once the allegation is raised, the court will look into it. And that has been the principle since 2005. The court has always examined the allegations of violations of human rights under the African Charter on Human and People's Rights. This is the first time the court is washing off its hands like Pontius Pilate. And I'm very confident that the court will never make that mistake again.
I understand what you're saying. So I want to know, what is so different with your client's case?
What is so different again, like I said? One, the composition of the committee. Right? And the most dangerous part, which I said, which the court didn't quite like after their judgment, I said, by your decision, you have warned judges in the sub-region that they could be sanctioned or penalized for their decision. In every modern state, a judge enjoys judicial immunity. You cannot penalize a judge for his or her decision. In this case, for the first time. In the history of the court.
So meaning this is unprecedented.
Unprecedented. The court endorsed sanctioning a judge for a decision. No, it has never happened. And it will never happen in a modern state. Because you are simply inviting anarchy. Where a judge will be looking, at the body language of the president before taking a decision, so that she will not be sacked. So, and I did say to the court, and the court didn't like it, that your judgment, we hope it to be made available as soon as possible, so that judges in the sub-region can study it and realize that they can be fired for giving decisions that are not in consonance with the wishes of the court. And if they come to the court, you are simply going to say, our hands are tied by domestic legislation. No, the court must never, different to that level. And I do hope that lessons will be drawn from this judgment so that the court can advance its jurisprudence as opposed to subverting its jurisprudence, which is what has happened.
Okay. Lawyer, I would want to say thank you very much for speaking with us.